Hello, we are Group S217 from the course Business and Corporation Law. We would like to thank our honorable lecturer, Mr. Jonathan Temple, for giving us the opportunity to work on the case called Kinsela and Anchor versus Russel Kinsela Private Limited. And also, we'd like to thank to him for giving us the platform to present the case to him. The reason for choosing the case was very convenient for us to work on, and we had to understand the duties that a director of a corporation possesses. By understanding the case, we have understood and elaborated our directors' fiduciary and statutory duties, the potential that they have broken, and what it serves to all our current and potential future directors must and mustn't where certain scenario materializes. Now I'm going to explain the director duties in a brief words. The director's duties explain the legal obligations upon director and officer. For a corporation, a director has three duties: fiduciary, statutory, and replaceable duties. Fiduciary, the word that comes from Latin word fiducia, relates the notion of honesty, trust, acting in the best interest of the people, entity that one is serving to as opposed to oneself. There are two classifications of directors' fiduciary rules. One involves loyalty, good faith, and another involves due care and diligence. While breaching the fiduciary duty, a director can be forgiven unless it's for reasons under some conditions. A statutory breach will lead to serious and unavoidable consequences for the director, as the latter means breaking the law. Now I'm going to explain the case description and the verdict of Kinsela Anchor versus Russel Kinsela Private Limited. The Kinsela and the Russel Kinsela case gave us a clear-cut indication about what the director's prime duties would be when the company is performing at a certain position. Members of the Kinsela families were renowned for directing and owning a lot of successful corporations. They had a reputation which has made the members of the company feeling proud. Thus, the members, who are also the directors, have decided to carry on a business as a funeral director, also known as undertakes involves in the business of funeral rites. The case was true for all of their corporations except for one. That corporation is called Russel Kinsela Private Limited. Russel Kinsela was already at a loss due to not extracting money from its operations. The biggest reason for their conditions came via cost-free operations that came from small regular payments by their clients for free schemes. The liability arises when they give lease as lower market value. The company became insolvent. During liquidation, the lease was challenged. The director was unable to pay the creditor's liability. Thus, in late 1976, they were suffering losses, and inevitably that led them to bankruptcy. A case cited with approval in many jurisdictions, the New South Wales Court of Appeal was faced with claim against directors who, on behalf of the company, entered into a lease of company's premises for their preference for 3-year option on 26 January 1981. Not only that, they used it to rent the premises was below the market rate for rental. The time they traded, they were declared insolvent. And just a couple of days after leasing the premises, they were officially winding up as an organization. Thus, they have already breached the statutory duties by engaging in insolvent trading. In the case Kinsela versus Russel Kinsela Private Limited in liquidation 1986, it was declared that the director acted in breach of its duties and their conduct were detriment towards the creditors. During the liquidation, it was decided that the company asset would be the asset of shareholder. Now I'd like to invite another group member who will explain you what it all went wrong about the cases in a while. Thank you very much.
Thanks, Russel, for giving me the opportunity to carry on the presentation. So now I'm going to discuss where did all went wrong according to the Kinsela and Russel Kinsela Private Limited. Since insider trading as an illegal act and director did not intend to intrude for this winding up, So that there was the director were held accountable for. And the director duty doesn't end till the end company life. It goes beyond that, where the corporation is insolvent, their duty of care and their purpose should be the first serve to the creditors. Unlike during the existence in which the director's primary interest to shareholders, therefore they did not realize the extent of their duties and paid the price heavily for it. So there was in the back foot, and the fact there is act has taken place between Funeral Funds Act 1971. So, like for the Kinsela, which came into the operation of October 98, the Act enforced that directors, insurance companies who engage in funeral insurance schemes to disclose their financial information upon a statutory director, which is later to be interpreted should be the company engage in solvent trading. Okay. So now I'll look to call my another member to carry on the rest of the presentation.
Hi, thanks to my friend for giving me opportunity. So I'm going to describe ratification of Kinsela and NN versus Russel Kinsela Private Limited. The duties of director lie on companies, not an individual shareholder or themselves. Just like all sinners have a future and all saints has a pain, director sections are forgiven in general law. If a director has breached to act in a good faith, proper purpose and improper interest in director can be ratified based on following ways, like compensation. The director accepting to pay the damages that caused by breach of their fiduciary profits, an account of profits. By doing that, company can restore corporation property. The rescinding of contract in which the director had an undisclosed interest. And now, why the ratification wasn't granted? One of the biggest reasons why Kinsela didn't get ratification as when the company is insolvent, the director's duty is on to the creditors. When the creditors give loan to the companies, they do it with trust so that the receiver can pay duty on time. If the creditors don't get repaid, then the trust will lose and then credit system will collapse. In case of unfortunately ASIC is one who will bring in the brutal approach of punishing them by law. While the guilty hadn't committed fraud against the minority shareholders, unlike Cook and Dick's case where Dix was a minority shareholder who was victimized by the other three shareholder attempts to move the operation from their existing organization to a new corporation owned by later three. And next part is what the case sums up in the director duties during winding up. Even though the corporation is an artificial entity, they are vulnerable to disability. They can't act and think on its own as the individual, thus allowing the complex mechanism of human agency of function. Thus, the director is as responsible as the administration and the management. They can also act as managing partners of partnership business or trustees, where they can hold property interest for another. That's all.
Well, thanks Kawal for giving me this opportunity to run the presentation. Now I'm going to present my part as limitation and conclusion. So in the limitation, the biggest limitation of the report include using more cases to explain the director's duties under such circumstances, as it will exceed the purpose of the case and it's tedious to do that on a 2000-word report. So at the conclusion, this Kinsela versus Russel Kinsela case gave a very clear indication that being a director of the company is like being given the power to either become a superhero or a supervillain. Perform the duties well, then they will be praised and be kept at the top for years to come. Prioritize their personal interest more than that of entity of character, and they will end up breaching duties. While breaching duties, they must make sure that what they do is fiduciary, that statutory, otherwise there will be no way out for them. So our recommendation would be to find a right balance between these two. While doing for the best interest of the company is mandatory, gaining yourself monetary and other benefits from this action is highly attainable. Thank you very much.
In the end, I must say that we are all indebted to Mr. Jonathan Temple for giving us the opportunity to work on the case, from where we learned so many stuff about the law. Thank you very much.